Good afternoon and welcome to the Environmental Law Institute. You have joined us for Basics of Land Use. My name is Caitlin McCarthy and I'm the Director of Education, Associates, and Corporate Partnerships here at ELI. We're delighted to welcome everyone to ELI's annual summer school series, and I encourage you to join us every Tuesday for summer school. For more information, please see the events page of our website, eli.org. I will note that every summer school seminar will be taking place by webinar only this summer to ensure the safety of our panelists, participants, and staff. We thank you for your understanding and for joining us. At the end of today's panel, we will have time for a questions and answers session. Please submit your questions using GoTo's question box, and please do not wait until the end. Send your questions as soon as you think of them. I would like to thank our outstanding panelists for joining us today to lend their expertise to summer school. While I will introduce them briefly, the full speaker bios are posted on our website, eli.org, and I would very much encourage you to check out their experience in more detail there. So to kick us off today, what is land use law? On the surface, it's very straightforward. It's the law governing land and how it's used. But this is obviously a multifaceted area, and it covers a huge spectrum of legal and policy intricacies in practice. I'm excited for you to learn from our panelists today. Some examples of what land use can do are obviously in regulating and helping human health and the environment. Land use planning can reduce urban sprawl, it can preserve green spaces, it can limit soil erosion and contaminated surface water runoff. There's obviously a huge spectrum of things, within and without the environmental law sphere that intersect with land use. And so these are really just kind of the beginning of things that we'll look at today. The last thing I'll note here is that land use law can be very contentious. Some people understandably feel a strong sense of this is our land and how we use it. And so having that kind of in the governance sphere can sometimes make things really complex or contentious. But we'll hear a little bit more today about how these issues are handled and see some case studies of how they play out in real life. I do want to touch briefly on regulation. So you'll learn more about regulation from our great faculty today. But overall, land use is really regulated more on the state level, on the local level. It's not as much on the federal level. There are exceptions to this, of course, the first one being land that is managed by the federal government. This is not just national parks, but lands that are, mined that have farming or agriculture or grazing on them, mining, etc. And then another big exception, a lot of you joined us for ELI's summer school on the Endangered Species Act. There's a big intersection of when Endangered Species Act and land use come to play. You saw that quite a bit during that session with the dusky gopher frog, and it's just definitely an area to keep watching on. Lastly, courts obviously play a role here, but again, the biggest role really is with local governments and state governments, as you'll learn more about. So the focus of today, these are our primary goals: to really examine the foundations of land use law, these legal frameworks, and to look at the conservation aspects and components of land use law. As you see, we're going to cover quite a variety of topics and really see how land use law works in unique ways. We have phenomenal faculty joining us today that each represent really different areas from each other, and we'll be able to walk through their work in land use from their various professional backgrounds. So I would now like to introduce our outstanding faculty today. First, I'd like to welcome Heather Delapolsky, partner at Wire Gill. Heather works on all matters of land use and zoning issues for projects including mixed use, multifamily, and commercial properties. Her clients have included commercial and multifamily developers, institutions, and churches, among others. She provides skilled representation on land use, planning, and zoning processes such as CR zone optional method development projects, master plans and sector plans, and conditional use special exemption applications. Heather, we are so thrilled to welcome you back as summer school faculty. Next, I'd like to welcome Sarah Everhart, a research associate and environmental specialist with the Agriculture Law Education Initiative at the University of Maryland Francis King Carey School of Law. Professor Everhart is a graduate of Washington College and cum laude graduate of Pace University School of Law with an environmental law certificate. She began practicing law in Maryland in 2005, and her areas of expertise include land use law, labor law, and environmental policy. She is also a trained mediator. Sarah, we're delighted to welcome you back as summer school faculty. And of course, we're happy to welcome Emily Parrish, the Vice President of Conservation at the Land Trust for Tennessee. Emily is a veteran conservation leader, both in Tennessee and at the national level. Since joining the Land Trust for Tennessee in 2004, Emily has been instrumental in protecting more than 120,000 acres of land. As Vice President of Conservation, Emily oversees the Conservation and Stewardship Program. Emily, we're thrilled to welcome you back as summer school faculty. With that, I will gladly turn things over to Sarah to get us started.
Thank you, Caitlin, and thanks everybody for tuning in this afternoon. So I am going to start off here with sort of a broad overview, talk about some of the historical underpinnings of planning and zoning, hopefully not put everybody to sleep. Hopefully you're having a light lunch today, and we'll try to keep it moving. And then, you know, like Caitlin said, we've got a great group here. Heather's going to give you a little bit more of the practice-oriented side of this, and Emily's going to give us a really important conservation view. But, you know, in the beginning, before there was planning and zoning, there were nuisance claims. And I think that's an important place to start with land use law, because that's really where planning and zoning came from. They were established, both of, you know, these areas, which, you know, planning and zoning are different. We can't use those words synonymously. I'll talk about that a bit. Heather's going to talk about that a bit, but that's sort of an important thing to say just right at the outset. Very different concepts, interconnected, but not the same. Land use law is based in those principles, and so for those of you in law school or anyone, you know, who's knows a little bit about what nuisance claims are all about, it's a balancing test. And so you're balancing the right for you to be able to use your property versus your neighbor's right to quiet enjoyment. What does that mean in terms of zoning? Well, that means that the reason that jurisdictions, towns, counties are trying, the reason they adopt zoning laws, that they make all these zoning classifications, is because they're trying to prevent those nuisances before they even start. So they're going to restrict your right to use your property in certain ways, because if they don't do that, if you have total free reign, you know, you could open up an industrial factory type use in a residential neighborhood, and then that balancing test is going to be off, because your right to use it is going to be causing too much harm to your neighbor's right to be able to sit outside and enjoy a beautiful day like today. So there's some debate about really, you know, what exactly was the start of zoning. There's definitely some early examples in Los Angeles and New York City, but most folks can agree that there was a standard state zoning enabling act, and that really got things moving. This was a government model act from 1924, and if you look at that now and compare it to your local zoning law in your jurisdiction where you live, you'll probably see a lot of similarities. So it really was pretty widely adopted. The reason, you know, was some of the things I was just saying. One of the, you know, the types of uses they really wanted to protect through these zoning laws were single family homes. They wanted to be able to protect people's, you know, property investments. So if you spend all this money on a house, especially in this current market, you know, if you spend a lot of money on a house right now, you want that money to be a sound investment. You want to know and have some surety that the uses around it are going to remain constant, and that, you know, your property is not going to drastically decrease in value because of somebody else's use of land nearby. So it's really about stability. So we had that Standard Zoning Enabling Act in 1924, and then we had the Euclid case. So this was a Supreme Court case, and this was the first real test of zoning authority. It was all about a town in Euclid, Ohio. They had passed a zoning law. Previous to that, a realty company had owned a chunk of land. As you know, as you can imagine, the zoning ordinance passed, divided the village into several different districts. And after that, the realty company, their investment, they felt it was not as valuable as it was before because the uses were restricted. So previously, they didn't have restrictions, zoning law passed, they couldn't do everything they wanted to do on all those pieces of property. The town said, hey, we need to do this. We need a zoning law. We need it for a variety of reasons. So the fire department can have access to residential homes, decrease traffic, improve the overall quality of life for the people in Euclid, Ohio. These are reasonings that were given by a town in 1926. I'm sure my colleagues would agree. These are the same things that most towns or counties would cite today. So we've come a long way, but what towns are trying to do with zoning hasn't changed too much over the years. It's often related to public safety, and we always throw traffic in the mix. So the Supreme Court took a look at this and said, you know what? We think that the town was within its power to do this, and as long as zoning is not done in an arbitrary or capricious way, it's a valid use of local police powers. And so, the one connection that towns or counties have to make here is there has to be a rational basis for the zoning law. I'll explain that a little bit more in a bit. But after Euclid, after the Supreme Court, in lack of a better word, blessed this zoning regime, was really a proliferation of zoning throughout the country. And this is where the term Euclidean zoning comes from. So that's sort of the underpinning of that. One of the interesting pieces of that opinion was the majority's reference to an apartment building being a parasite. I think that's important to think about and point out, just because I like land use law a lot. I'm sure my colleagues feel the same way. We're passionate about it. We'll hopefully give you, some examples of some really positive and powerful things that can be done through planning and zoning. But there are choices that have to be made, right? There's categories, there's things that you're allowed to do, there's things that you're not allowed to do. And jurisdictions have the authority to make some of those judgment calls, under the auspices of zoning. So they're going to decide in this certain part of this jurisdiction, we want houses, we don't want apartment buildings. That can lead to exclusionary zoning. And I think that that's just an important thing to mention, put out there. There's, that can be very problematic. It's not an untarnished history in terms of land use law and planning and zoning, especially related to exclusionary zoning. And so just sort of something to think about as we go along. Following that, we had a Standard Planning Enabling Act. So this was the birth of the separate comprehensive plan. So the zoning law is one thing that categorizes what you can do, where you can do it, those different permitted and unpermitted uses. And then we have this separate planning document that's, Heather will talk about this a bit more, could be referred to as a master plan or a comprehensive plan. It's a long range vision for how the jurisdiction wants growth to happen, where they want uses to be within the jurisdiction. And, it's supposed to be a guidance document. However, there does need to be conformance with those between planning and zoning, and how to conform planning and zoning remains something that we continue to wrestle with to this day. And so, if you go on to practice in this area or learn more about it, I'm sure you'll end up wrestling at some point with a decision and trying to decide if a use or an action is consistent with one of these planning documents. All right, so Caitlin mentioned that usually this is local. I agree. It can, vary state by state, and it's important to take a look at it state by state, but generally speaking, pretty fair to say that land use is inherently local. How did that happen? Looking to the Constitution, according to the 10th Amendment of the Constitution, powers not specifically delegated to the federal government go to the states. So I like to call this the kick your can authority. So the government kind of kicked the can on this one. We're going to say, because of the 10th Amendment, we're not going to get into what goes on in various jurisdictions. We're going to let that go to the state. And so that's really the constitutional underpinning, or the allocation of how states have as much control over as they do over zoning. And then states have this power, but it's under the auspices of police powers. So we often refer to the power to pass laws to protect the public health, safety, and welfare. And those are called the police powers. So states can do a lot of different things, but they have to be tied to those general characteristics. That has to be the reason why you're passing these zoning laws. not just to restrict uses for restriction's sake, but you're doing it because you want to protect the public health, safety, and welfare. Again, kicking the can. Many states, vast majority are going to delegate that authority to the local governments. Depending on the state, most states are going to say, hey, and we're sitting here in the state capital, we're not the best people to decide how land should be used in municipalities or in a county, 1,000 miles away. That should be something that's done on the local level. So important to take a look at the individual state constitution of where you end up practicing, or if you have an issue, look for that enabling authority and make sure you understand it, because it can be a little tricky and it's going to vary jurisdiction by jurisdiction. All right, just to highlight a couple other components of land use law that come directly from the Constitution. Looking at the Fifth Amendment, I tried to make that little semicolon there in the middle of this quote bold because it's an important semicolon. Think of it as a big slash, because we're really talking about two different things within the Fifth Amendment here. So we have protections that we cannot be deprived of property without due process of law. I'll talk about that in a minute and how that plays out in this context. We also have a protection that you can't take my private property without compensating me for it. So that's a takings protection. A taking is where the government's going to directly take your property, either physically, and if you're interested in learning more about takings, I'd take a look at the recent Cedar Nursery case that just came out of the Supreme Court. Very interesting decision in the takings context. Most of the time we're dealing with regulatory takings, and what that means is this zoning law is so restrictive that it's taking my use from me and I'm not being compensated. So, put yourself in the shoes of the realty company in the Euclid case. Hey, yesterday I owned 68 acres and I could do whatever I want with it. Then the town went and passed the zoning ordinance and now it's not worth as much. Now I can't do everything that I could do before. I feel like something's been taken from me and I should be compensated. So that's what a regulatory taking is all about. Due process comes in two different forms, both of which are important in land use law. Procedural due process, that is, in a word, openness and fairness. So it means that you should have a right to what's going on procedurally in this world of planning and zoning. The meetings should be open. You should be able to attend them. You should be able to cross-examine people. There should be a record created, a written determination, and a right of appeal. So not sure how many of you have ever been to a planning commission meeting or a board of appeals proceeding or something in this realm, but if you never have and if you're interested, I encourage you to go, because you can. It's your right to go and watch and listen, and you can often see how these different situations play out, and whether or not this is a part of environmental law that you'd be interested in pursuing. I assign my students in my land use class at University of Maryland to go and observe a hearing, and sometimes they scoff. Oftentimes they come back happy because it was entertaining. They see people crying, they see people yelling. People get very passionate about their property. So check it out if you never have. It's your right to be able to do so. The other side of due process is substantive due process. And that really means the right to be free from unreasonable or arbitrary governmental interference. In other words, the government shouldn't be able to pass laws that are inherently unreasonable or unfair. So, like I said before, a land use regulation has to have some underpinnings to the protection of police powers, and there has to be a connection between the restriction and a legitimate government purpose. What does that mean in actuality? Well, it's pretty common for a use to have setback requirements. So, okay, we're going to let you run a landscaping business out of your residential house, but we want you to have 100 feet from your neighbors. You can't store piles of mulch, you can't have heavy machinery. If you're going to have employees in there, they can't come screeching in in their trucks before 8 o'clock in the morning. All of these different types of restrictions can be put into place as long as there's a connection. So there has to be a connection between the restriction, what the government's taking away, and what they're trying to achieve. The 14th Amendment, you all have probably heard about this. So, this is what allows the states to also fall within the auspices of this with due process. And then it also brings in this equal protection, the sort of the realm of equal protection. So sometimes folks get a little tripped up with this, especially with land use law, where it seems to be we're definitely categorizing things and splitting things into groups. Equal protection is going to protect us from some classifications. Equal protection requires that the classifications, the specific groups have to be treated similarly. So how that plays out in this context is that land in the same zone has to be subject to similar regulations. So we do have to be treated equally and have equal protection, but we can make different categories, but the people within the categories need to be treated equally. And classifications are permitted if they're reasonable, rational, non-arbitrary. Where jurisdictions run into trouble, if they start making classifications based on suspect classes, race, religion, national origin, alienage, that's when there could be a viable equal protection challenge, and those laws would probably not be upheld. A little bit about hearings and appeals, and I know my colleague Heather will talk about this also, but zoning bodies and appearing before them as an attorney, I think it's worth mentioning. It's different than court, and sometimes I feel like maybe if you don't have an opportunity to take a course about this in law school, you might not hear too much about it. But zoning bodies are typically not bound by the technical rules of evidence, and so that can be good, because it can make things move a little bit easier. It's easier for folks to appear without an attorney, pro se. However, it can be a little awkward if you're the attorney representing someone and the other side is without an attorney or pro se, and then you're trying to sort of introduce evidence and build a record. Sometimes as a lawyer, you can kind of feel a little bit like you're maybe being too formal in an inherently informal setting. But it's really important to build that record, because as you'll see, that's the basis for your appeal. So remember those procedural due process rights. You have a right to have a record. That means that's the evidence of how that administrative body came to that decision. So they just can't say, this is our decision and that's it. They have to show you the reasoning, how they got to that decision. And that's going to be your basis for your appeal. Whether your client's going to have standing to appeal is another important issue. So, as I said, sometimes people can get, really upset and feel very passionate that they should have a right to appeal in a land use matter because they've lived in the town, or, they've got a vision for how things should go, but not everybody's going to have zoning. And so you got to pay close attention to whether your client is actually going to have zoning to an appeal and a decision. And another tricky thing in land use law is making sure you've exhausted all those administrative remedies. So jurisdiction by jurisdiction is going to have varying levels of administrative proceedings that you may have to go through. Clients don't often love it because it's expensive and time consuming, and they just want you to just appeal it, get rid of it, just let's go to court, let's just get it done. But, we have to make sure you exhaust all those administrative remedies before you get to that appellate level. The review of these decisions is often based on whether or not the factual findings were based on substantial evidence. So like I said, there's got to be the reasoning has to be there. What were the facts in the record that led to that decision? The appellate court's going to look at that record and try to figure out, hey, did the zoning authority, did they have a reason to do this? Oftentimes it's going to be, appealing one of those decisions can be tricky because the courts are going to defer to the local guys. Again, it's another aspect of zoning being a local matter. Courts don't often like to substitute their own judgment for that of the local authority. So if the record's there and it supports the decision, it's going to be hard to appeal. Few of my own personal thoughts about land use and zoning. It's great. I think, because it's intergovernmental and interdisciplinary. So you get to sit on teams with scientists, engineers, you know, you name it, a lot of public works folks from the town. You know, you're not just dealing day in and day out with only attorneys. So if you're the type of person that likes to work on a interdisciplinary team, if you don't just want to be in the same courthouse your whole life, or, you know, pinging around between courthouses, if you'd also like to be a part of administrative things, maybe sometimes go to court, sometimes be in front of administrative bodies, it's a great field for you. I don't find it dull. I think it's exciting because although, you know, it's not always ever evolving at a rapid pace, it does evolve. You know, zoning and planning, Heather will talk to you about some recent trends. I'm sure you could all think of things right now where we're seeing conflicts, you know, things like Airbnb, you know, those types of things, you know, they're constantly popping up, and zoning and planning has to respond to that, and it does respond to that. So things change over time, which is nice. As a young attorney, sometimes, you know, sometimes some of these matters can be kind of on the small side, and if they're on the local level, you know, you can be representing folks on the local level, and you can be a part of, you know, making some of these really important decisions. So I liked that as a young attorney, being able to go and represent my client independently, you know, didn't always have to have a team of attorneys with me, and got to know the people on the local level, and some really important things can come from that. Couple recommended resources for you if you'd like to keep up with some of these decisions. Professor Patricia Salkin's got a great weekly blog called The Law of the Land. So you could subscribe to that, and that blog will send you national cases of import for land use law. Like I said, attend your town or county's planning commission or board of appeals proceeding. So go check it out. It's a great thing to do if you're wondering if you want to pursue a career in this. It's also a great thing to do if you get a client who's got a matter coming up in a couple months. Go watch the Board of Appeals and see how they rule on things. See what they seem to be approving or disapproving. It doesn't have to be a mystery. It's public. You can go watch it and figure it out for yourself. And then I'll say this with a caveat, consider serving on a planning commission or on a Board of Appeals. If you're in a firm where you want to be practicing land use law in that jurisdiction, it could create a conflict. However, you know, if you live in a different jurisdiction than where you're practicing, or if you're not currently practicing land use law, if you're doing something else for your career, but you still want to keep a foot in this area, they love having lawyers on those boards, and oftentimes they're looking for folks. It can be really great experience for you to serve on one of those boards. So with that, I will pass it over to Heather.
Great, thank you, Sarah. Just make sure I can use the PowerPoint here, and everybody hear me? Good. So, all right, thank you so much, Heather Delapolsky, and really appreciate Sarah's presentation. Much as I'm a land use and zoning attorney in private practice, and I've been doing it for over 15 years now, I actually have never taken a land use law course in my life. I went to Vermont Law School. I studied environmental law there. Find myself doing land use and zoning law for my career, but always appreciate Sarah's presentation and just sort of an overview of the legal underpinnings of land use and zoning law. So yes, I am a land use and zoning attorney. My talk today will really focus on daily practice. And interestingly, I find myself thinking this a lot, and sometimes even saying to development teams that, you know, I'm more of a quarterback in a lot of ways. So sort of, you know, dealing with communication and community relations, and communicating with the jurisdiction that governs the area. And a lot of just sort of keeping all of the pieces moving forward, and just so much on communication and transparency. So I sort of, you know, tell our clients that if we get to the point of a project, we're like pounding the table and saying, but the law lets us do this, you know, we probably already went astray somewhere, because sort of those other pieces are so important. And I think especially today, especially in this modern era, especially in the recent years that we've had, where, you know, community conversations, transparency, openness is just so important. We won't always all agree, but just having that communication piece, I find that that's actually sort of most of my job these days. So I will talk about land use and zoning, obviously, in my talk today, but also try to touch on those other pieces too, because in some ways I think they are as important, if almost not more so. Okay, so I think Sarah really gave a great overview of this, so I won't go into detail. I should say I practice in the counties in suburban Maryland, essentially the counties that touch the DC Beltway. So that's the experience that I'll be talking from today. But I think that sort of the broad principles apply more broadly. And I saw from the attendee list that folks are attending today from all across the country and then some. So hopefully some of these principles themselves, I think, are applicable in your local areas. So as Sarah mentioned, land use and zoning authority is derived from the police powers. Under Maryland law, these powers are then sort of conveyed to counties and municipalities within the state of Maryland. Police power definition is up there, but I think Sarah did a great job of covering it. And as you also heard, state and federal law, I guess should say primarily, federal law does impact state and local land use and zoning through things like the Fair Housing Act and other items that you have up there. But largely this is really state giving powers to the local municipalities and counties. So that's really what we'll focus on today. So powers that are granted. In Maryland, the specific powers that are granted to a county really depend on what type of county it is. So that is something that you need to check, what type of county am I functioning in here? And whether then a specific county or a specific municipality has actually taken advantage of the powers that they are allowed to adopt under state implementing laws. So perhaps a county is allowed to adopt affordable housing regulations, but they just haven't chosen to do so yet. So that is a possibility. So there's sort of the broad category of laws that counties and municipalities can implement. They don't always. So it's very important to read your local county, municipality zoning ordinance text. Another thing to note, some municipalities have land use and zoning authority, others don't. So you may have a municipality, I'll say here, City of Rockville is a place in Maryland. It's located in a county, Montgomery County, but it itself has land use and zoning authority. And so it's the City of Rockville's municipal land use and zoning that applies. If you're outside the city, you'd be under the county. So this is very important. This comes up a lot in areas that I deal with, and I'm certain areas around the country where whether you're located in an unincorporated area or an incorporated municipality is very key. And that's fundamental, because I've definitely had cases where I've been pulled in and folks before me have done an analysis and said, well, the county allows this. And I say, well, that's nice, but you're in a city and it's a totally different ball game here, and then sort of have to give that different news. So that's a critical piece to check, is who governs you. Types of powers, we're going to go over some of these today. We will go over land use and planning. We'll go over zoning, subdivision, adequate public facilities. Not enough time in the day to talk on the rest, but affordable housing, that's things like moderately priced dwelling unit programs, workforce housing programs, historic preservation speaks for itself. Planning for streets and roads, again, speaks for itself. And there's all different types of powers, environmental powers, other things. So like I said, not enough hours in the day. So planning versus zoning. Sarah touched on this. This is a critical key distinction. I will say, I think that in some ways the lines have been a little more blurred in recent years, at least where I practice, probably in other places too. But we'll talk about that a little bit. So what is planning? Planning is sort of big picture. It's broad. It's high level. You can see there county and city planners create policies to encourage development that will serve the needs of the public in the future. So very broad. This is planning is sort of the police powers, the public health, safety, and welfare big picture. Planning guides land use. It is typically advisory, and it typically does not have the force of law. So a plan may apply to the whole county, or it may apply to an area in the county, and it's a guide. It lays out big picture. This is what we want to see here. This is what we want to see here. Typically, it doesn't usually get down to the individual property level. What is zoning? You've got a definition up there, which everybody can read themselves. Zoning itself is property specific. So zoning gets attached to every individual property that lies within whatever that jurisdiction is. Zoning is identified on the official zoning map for the jurisdiction. So you can look up your property. You can see you're very specific. This is the zoning of this site. The regulations that govern the zoning of any given site are included in your county or your city code text. So typically that's called the zoning ordinance. And your zoning is binding. It's not merely advisory like the land use and planning function, again, is typically advisory, but we'll get into that. So types of land use planning actions. So remember, again, these are the broad ones. These are the big picture, not necessarily attaching to specific properties. There could be things called general plan. General plans typically apply to like the whole jurisdiction. So I'll show you an image in a little bit of an excerpt from the draft new general plan that Montgomery County, Maryland is doing. So general plan in that case applies to the full county. You can have something called a master plan that would apply to something of a smaller area. So folks familiar with Maryland, there's a master plan for the Bethesda Chevy Chase area. So again, kind of going down in levels of granularity and detail here. Sector plans, again, this is still land use and planning function, but it's going down a bit more narrow. So much as there's a master plan for the Bethesda Chevy Chase area, there is a sector plan for downtown Bethesda. And then you have these functional plans. Functional plans are incredibly important, and I think actually are becoming increasingly important and really important for property owners, land use and zoning attorneys to follow. It's funny, this is something that's been in education for me in recent years, and particularly the jurisdictions that I practice in. They're pretty sophisticated in terms of planning for transportation, planning for mass transit, planning for environmental things. Bicycle master plans. Montgomery County's implemented a bicycle master plan, basically laying out the vision for bicycle lanes throughout the entire county. You know, you don't really think that this has that much of effect on your property, but it does, because if you are coming in, if you, your client, are coming in to redevelop a property and the bicycle master plan proposes a shared use bike lane along your frontage, because you're seeking redevelopment, you are responsible for either implementing or contributing to your pro rata share of the cost of construction of that bike lane. And these are not inexpensive. These are really nice bike lanes. This type of thing, and I've had this happen personally on several of my cases, so giving you good information here, has the potential to be several hundreds of thousands of dollars of improvements added to the cost of redevelopment of a property. So very important, pay attention to those functional plans because they will find you when you seek to redevelop. Just want to touch on trends in planning, and I should have given attribution on the screen itself, so I'm just making a note in my presentation. This is an image from the draft update to the general plan that Montgomery County, Maryland is pursuing right now. It's up at the county council. There are some things here that I just wanted to highlight very briefly, and we can certainly get into it in Q&A at the end. But you know, you've got things like equity. So diversity, equity, inclusion is a huge piece of what we've been all hearing about, you know, increasingly in recent years, and certainly so in the past year or so. Environmental resilience, these are things like climate change. How can we make our areas more sustainable, stronger against climate change, which, you know, certainly who knows exactly what happened in the horrible tragedy in Florida, but I think anybody in the land use and zoning world, you know, is thinking about climate change with respect to that. Certainly New York City is evaluating the effect of climate change on their land use planning and zoning. So we have here affordable and attainable housing. I think Sarah mentioned in her presentation that I'm not going to get the wording right, but that an apartment was it wasn't a plague, but it was something like a plague. And it's interesting because we still see that today, where folks, you know, I have projects that are multifamily residential, and one of the first questions we'll often get in a community meeting is it for sale or for rent? And if you say it's supposed to be for rent, people are not always that happy about it. There's this view that renters are somehow different. So, you know, these are tough things, just really tough things that, you know, governing jurisdictions have to grapple with in the land use and planning function. So we can talk more about it in Q&A, but, you know, we're just seeing how I think things in our society are manifesting in land use and zoning itself in terms of ongoing difficult discussions. The types of zoning actions, excuse me, we have zoning and rezoning. There's sort of three main types of those, and I'll go into those in detail in a little bit. You can see the bullet points underneath. We also have things called special exceptions, often called conditional use. The language is sort of interchangeable, and then variances, and we'll go into each of these in a little bit. So I just wanted to show a sample of a zoning map. Hopefully you can read it okay on your screen. This is a zoning map. It's actually a project I'm working on now, just east of Silver Spring. And you can see here the different colors, the different letters and numbers, all represent a different zone that you can then cross-reference in the zoning ordinance and understand the regulations that pertain to it. So just another excerpt here. You can just see this is neighboring Prince George's County, Maryland, somewhat near College Park. And again, you can see the different classifications of zoning. And of course, then those cross-reference to zoning ordinance text. This is a use table. So sort of two main pieces of zoning are what uses are allowed, and then what are the development regulations, like the height, the setback, et cetera, that apply to it. So you can see here, you've got permitted uses that essentially it's just allowed. Limited, this is, I should say, excerpt from Montgomery County, Maryland. Limited in that if it's limited, it means there's some sort of constraint attached to it. So you have to read the text to understand that. If it's a C, it means it's a conditional use or a special exception, and we'll talk about what that means in a moment. And then typically, if it's blank, that means if it's not permitted, it's prohibited. And then, as I said, the main regulations attached through zoning are the use table, what use is allowed, and then the development standards. So again, this is from Montgomery County, Maryland, just an excerpt of one zone's development standards. You can see things like open space requirements, site coverage requirements, lot width, density. Other things you usually see are height, setbacks. Those are sort of the main pieces. There can certainly be other ones, but those are, I think, the main categories that you typically see attached to a property. One other thing I wanted to mention is overlay zones. So you could have sort of your base zoning, and this is a site in Silver Spring, Maryland. In the areas that are shown crosshatched, that is what's called the Ripley South Silver Spring overlay zone. It's very important to understand if there's an overlay zone on top of your base zoning, because overlay zones can do everything from just sort of provide a little bit of an additional guide, like maybe it provides for some more detailed architectural review, or sometimes overlay zones can actually fundamentally pretty much just change the underlying base zoning. So make sure you're reviewing your base zoning, finding out if there's an overlay zone, and then determining what that overlay zone also says. And then you get to do the fun job of sort of meld it all together and figure out what that all means. So special exceptions and conditional uses, you can see the definition there. It's a grant of a specific use that generally wouldn't be appropriate, but may be found to be appropriate if certain findings are made, and potentially some restrictions associated with the use. So types of these uses, and this is just very generally speaking, obviously you have to read your use table, but things like hospitals, larger assisted living facilities, larger daycare centers, so not necessarily smaller ones, but larger ones, golf course uses, almost anytime you have a commercial use in a residential zone, those are sort of things that merit a little bit more scrutiny. And so, as I mentioned, this is, conditional uses, special exceptions, typically can only be approved if certain findings are made and maybe conditions are attached that ensure that the findings are satisfied. You can see, again, 5 bullet points. These are sort of typical findings. So satisfies requirements of the zone, that's self-explanatory, complies with the master plan, other applicable plans, functional plans. You can see this is where sort of that planning function starts to become a little more binding than just advisory because of these sort of discretionary findings. Compatibility doesn't adversely affect the character of the neighborhood, compatible with the neighborhood, and then will be served by adequate public facilities. I think Sarah mentioned this. This is oftentimes traffic and transportation is the big thing. Will the project overburden the nearby roadways? Also, water, sewer, schools, police, fire. So those are the typical adequate public facility standards. We call them APF for short usually. So variances, variances are with regard to the development standards that I mentioned. So this is when you're seeking some sort of a modification to things like density, to things like setback, to things like height. Variances also have a legal standard and findings that need to be made. I would say variances are actually, especially in what I would say are, sophisticated sort of urban jurisdictions, they're very difficult actually to satisfy. So, for example, economic hardship is not something that really carries the weight of a variance. So if a client says, well, I'm only allowed to build a 7-story building, but for the economics to work, I really need 8 stories. I want a 1-story variance. No, it's, you've got find another reason. So typically, it has to be unusual or extraordinary situations or conditions exist specific to the property. So it's not just that you can't do what you want on the property, it's that there's something very unique about the property that you can't satisfy the development standards that usually apply. So some jurisdictions are a little squishier in finding that these findings are satisfied, but I often tell clients variances are very difficult. So you got to have a really good reason, and it can't be just that you want to do something or that you have a personal hardship. So rezoning, few different types of ways to seek rezoning. I think folks have probably heard of the change or mistake rule, where there is either a substantial change in the character of the neighborhood, or a mistake was made by the jurisdiction in doing the original zoning. That's a pretty tough argument. I've actually never in my practice done a rezoning by change or mistake rule. Largely that's because the counties, and again, especially larger sort of urban counties, they undertake the planning function pretty regularly. So every 15-ish on average years, they do a wholesale review of the general plan, of a sector plan. So, first of all, to say that a jurisdiction that takes 3 years to go through the sector plan function made a mistake is tough, because they were very deliberative and it took a really long time and there was a lot of process. But also to say that there is a substantial change since they did it when they do it so regularly is also tough. So like I said, never done a rezoning by change or mistake. Floating zone, however, those rezonings are done, and this is where you've got a zoning category that, it's been created in the zoning ordinance, but it doesn't attach to a property until someone seeks an application requesting rezoning to that floating zone. And in that case, again, certain findings must be made. It goes through a whole hearing process, but that's, I think, when you more regularly see rezonings. And then I would say, try to just avoid change or mistake or floating zone, because they're very expensive. They're very long. I mean, you're talking probably 2 years just for rezoning, and several tens of thousands of dollars just in legal fees. And that's assuming it doesn't get appealed to courts or anything like that. So best thing to do is just monitor when the jurisdiction is undertaking a rewrite to their plans. Because typically what happens is when a sector plan is redone, when a master plan is redone, it gives land use recommendations, but then the jurisdiction typically comes back in as soon as that plan is done and implements a rezoning process to implement the general recommendations in the sector plan. So try to just carry along with that, because the jurisdiction's undertaking the process one way or another, and you can go along with it and seek a rezoning of your property as part of it. No guarantee you'll be successful, but certainly less expensive to a property owner than a piecemeal rezoning. Subdivision, just touch on this briefly. You can see the definition of subdivision in the first bullet point there. You can have subdivision, you can have re-subdivision. So subdivision really can mean sort of taking a very big property and dividing it out into smaller ones. It can also mean taking a bunch of smaller properties and assembling them into a new one. It can take, basically the lines can be carved up anyway, but when you're carving up property boundaries, essentially that's subdivision. Just a general rule, you typically can't build a building across lot lines, and you typically do need a property to be the subject of a record plat. So that means something recorded in land records that shows the boundary of the property. So oftentimes, if a project has never been subdivided, you will need to subdivide it before you can pull permits or move to redevelopment. So I want to talk a little bit, and this will probably vary by jurisdiction, standard method versus optional method. That's what it's called here in Montgomery County, but I think the principle is broadly applicable. So in some zones, you have 2 methods of development, one being a standard method, which is sort of more of a by right. You can do certain things limited to certain heights and certain densities under a more simple process. But if you wanted to go to a higher height of what's permitted within the zone or a higher density of what's permitted within the zone, you may need to go through some additional review. This, as I said, here is called optional method. And that additional review is typically a lengthier public hearing process, and also what's called sort of discretionary approvals. So this is where something can't be approved unless findings are made, hence the discretion piece. And I would say too that this is where that that planning function becomes a little more binding, because one of the findings for discretionary approvals, also for special exceptions, is where it's the finding is, does the project substantially conform with an applicable master plan? So master plan, sector plan, functional plan. What does substantial conformance mean? I don't know, but it's not strict adherence, but it's also not like, yeah, it's more or less. I mean, it's substantial conformance is something. So that piece always becomes a little debatable, but it does take, that finding does take the planning function and make it something more binding, even if it's not completely binding to the, to the force of law. So I mentioned discretionary approvals. They could be called concept plans, sketch plans, project plans, site plans. You'll see that nomenclature. And underneath, again, these are findings from the jurisdictions that I typically deal with. But you can see that these sort of discretionary approvals can't be approved without the jurisdiction finding, generally speaking, that these findings are satisfied. And you go through a pretty lengthy public hearing process with your team to demonstrate that they are satisfied. So a little on judicial review, and I will say a little because I myself am not a litigator, thank God, and I really try to avoid having my projects get there in the first place. So I think I started to say at the outset, I don't do so much law of like, we are allowed to do this under the law. It's just working with the community, working with the neighbors, working with the jurisdiction, starting very early in the process. There's no guarantee that if you do all that, you'll avoid judicial review or appeals. But I, knock on wood, like to think that that approach does help in keeping people out of court eventually. So as I say to my clients, especially in terms of reaching out to the governing jurisdiction, early and often, talk with them early on, talk about what's allowed, what your vision is, just understand it up front and know what you're dealing with, and then, try to work together on implementing that. So that's my approach. In terms of working with the community and the neighbors, that is so important, and it's so important anyway, but just, so important just with the changing, I think, world that we live in. It's not really, I use this example sometimes, it's not really okay for a development team to, wear their big dark suits and carry their big briefcases and just roll into town and say, we are putting this here, and just, sort of steamrolling. I mean, I don't think that was ever really okay, but it's certainly not okay in our world today. So, educate yourself on the community that your client, and I say this as a land use and zoning attorney, so I speak about my development team, but, educate yourself on the community that they're seeking to develop in. What are the current trends? What are the concerns? What are the sort of touch points that people are talking about? Reach out early and often, and I think transparency is best. More information is better than less. People aren't always going to be happy about things, but they're really going to be unhappy if they're surprised. So I don't hide things with the community. I don't hide things with the jurisdictions. If we're going to disagree, we're going to disagree, but we might as well know it and have a conversation about it, and that's fine. That's just life. So sort of this, I guess, fifth bullet point here. Sometimes it's better to give in on something that will make the community happy, something that they really want or that they're really concerned about, than continue to fight. And so I do have these hard conversations with clients, and I think most development teams get it these days, that it's a communication process, it's a compromise. But sometimes you do have to say, like, look, in the bigger picture, if they really like 10 trees planted to buffer, the headlights from shining into their home or whatever it may be, like that's okay. That's really not a big ask. Like let's just work this out. So that's my approach, knock on wood. Hopefully that's why I don't end up sending cases to litigators too often. But you're not always going to make everybody happy. You're not always going to agree, but that transparency and communication is just so important. I think, yeah, this is my last slide. Not too interesting, but I work for a private law firm, land use and zoning practice. So I think these first 4 bullet points sort of talk more about like the law, but again, as I said, I think daily land use and zoning practice is so much just quarterbacking a team. And those teams are increasingly large and sophisticated. They're engineers, they're architects, they're traffic consultants, they're environmental consultants, sometimes they're historic preservation consultants, they're the client, and just trying to keep all those pieces moving forward, talking with the jurisdiction, talking with the community. There's just so many pieces to it. And again, if you're pounding on the table and insisting this is what the law allows me to do, probably trying the quarterbacking process and that community outreach and that reaching out to the jurisdiction early on. Again, not everybody's always going to agree, but hopefully you can, through that process, work out something that people can see, okay, this is a good vision for the community, and you can develop and improve areas. So I will stop talking now. I may have to turn off my camera for a second because I have an electrician coming in, but I will be back for the Q&A, and I appreciate everybody's time today.
Thanks, Heather. We'll now turn to Emily.
All right, thank you. So I am going to have some pretty pictures because I get to work in the field of land conservation. So I have the privilege of working to protect land across the state of Tennessee. So you're going to get to see some pretty pictures throughout my presentation. But so I'm going to definitely switch gears because I work in a different type of field, but it definitely intersects and overlaps with some of the things we've been talking about. And so, yeah, I'm the Vice President of the Land Trust for Tennessee. And so what is a land trust? And so we're typically private nonprofit organizations with a mission to conserve land and or water resources. And land trusts are different. We're going to talk about that in a minute, depending on where you're located. But here in Tennessee, we're a statewide land trust, which we work. So we work in, it's a pretty big state, 96 counties across Tennessee. Most land trusts work directly with property owners to help them achieve conservation goals. And so, and again, we'll talk about the different types of conservation that land trusts may participate in. Approximately 1,700 land trusts across the country. Different sizes, areas of interest. For example, the land trust movement really started in New England. So if you go to the Northeast, you might come across a larger number of land trusts, because I think the movement started, you can imagine a group of people got together to protect one piece of land, maybe in their town, and they, over time, have become their own land trust. So I always use Connecticut as my example. There's 120 land trusts in just the state of Connecticut, and that's a very small state. So they go and work, they might work in one county, one town, one watershed. So as you go further away from New England, and land trusts are a bit younger here, definitely in the Southeast, we only have about 8 to 10 kind of that would fall under that umbrella of land trusts working in Tennessee. So very different than Connecticut. So the statewide land trust model, there's not a whole lot of us. Vermont has a statewide land trust, Minnesota, but it's a little bit different model than you might find, in some of those other land trusts. We have a very broad mission statement, and we're going to talk about that in a minute, but some land trusts focus on just one type of land, or again, work in one watershed or one town. So it really depends. They're really different. I would say most land trusts also tend to be the friendly golden retrievers of the conservation world. So we're not usually the pit bulls fighting for the environment and chaining ourselves to trees or anything like that. And actually, I thought about this with Heather. We talked about going to public meetings and participating in public meetings. And people all the time try to pull us into a fight, over a development, like a community might cause. And we really try to stay out of local fights over whether a piece of property should be developed or not. If a landowner wants to work with us to conserve land, we do that, but we don't tend to get involved in local land use or policy in quite the same way that you might hear of like an environmental group. Some land trusts get a little bit more involved in policy, but again, we're usually like the friendly, let's all work together and find a conservation solution, not as much adversarial as some people think there might be. The Land Trust Alliance is the umbrella organization in DC. They provide guidance to the 1,700 land trusts. They put out best practices to all the land trusts called standards and practices. They also have an accreditation program that was launched about over 10 years ago. And that is land trusts who want to prove that they're holding up the best practices and doing the best work for land conservation. So there's now about 400 land trusts that have gone, maybe not 500, through the accreditation program, including us. So I'm going to talk a little, so yeah, our land trust individual work, at the end of the day, we are set up as private nonprofit organizations. So our work is guided by our bylaws and charter. Your mission statement talks about what kinds of lands and what your goals are. We have a board of directors that helps us set our priorities and gives us guidance on what kinds of projects we want to undertake. We have a strategic plan, both for the organization, and then we also have a strategic conservation plan. So Heather touched on some of these different kinds of plans. You might see like an open space or a conservation plan. We created our own internal conservation plan that guides where we work. And so a little bit different than the kinds of plans Heather touched on. But we also, we're going to be guided by what your conservation priorities are, what kind of values you want to conserve. A very clear example of that would be the Nature Conservancy. They tend to be very heavily focused on protecting rare species, habitat, and more of like the natural wildlife, wildlife type habitats. Where the Marin Agricultural Land Trust in California is very much focused on protecting working farms and working land. And so it just depends, again, what your local priorities are. And we're going to touch briefly on this, but our work is also can be guided by the Treasury regulations. Section 170H is where the guidance that allows landowners to do conservation easements for tax benefits. So if a landowner is pursuing that, we do have to look to those Treasury regulations. And then of course your internal policies and procedures, and I mentioned the standards and practices that are put out by the Land Trust Alliance. So our mission, just to talk a little bit about our specific work, is to conserve the unique character of Tennessee's natural and historic landscapes and sites for future generations. We have a pretty broad mission statement. As I mentioned, we're statewide. We work in a very big area, so we protect a lot of different kinds of land. And you'll see that reflected in some of our photographs. But we protect both natural landscapes, habitat, forest land, but also working lands. We do a lot to work with our local farmers here in Tennessee to permanently conserve farmland. I will point out the word historic in our mission. It's a bit unusual for a land trust to have that word in their mission statement. So we also protect historic landscapes that can be like a Civil War site or important Native American site, or sometimes it's the property around a historic structure to help protect the context of some sort of National Register structure. So we do have that, and it really was important to our board at the time that we help protect historic landscapes. I point that out because it's kind of different if you look at some of the other land trusts across the country. So since 1999, we've protected about now 130,000 acres. We've done over 400 projects. We were started here in Nashville in Middle Tennessee, so you can see that's the area of projects are here. But we also have an office in Chattanooga, so we have a lot around the southeast region of the state and up and down the Cumberland Plateau. All right, so we're going to get, this is where we come back to some of the land use and property law. But so how do we, all of us different land trusts across the country, how do we conserve land? So we do this, I'm going to talk about conservation easements because that's the primary tool that we use here at the Land Trust for Tennessee. So we're going to come back to that, but conservation easements is typically an agreement between a private landowner and a land trust to permanently conserve that land. And again, I'm going to come back to that concept because I'm going to talk about it more. Sometimes we are involved in direct land acquisitions, so that might be purchasing land outright. That might be a landowner who donates land to us in their life or by their will. A bargain sale is where you sell land below fair market value to a land trust or a government. So it has some, you would receive some sort of cash, but you might also have a donation component of that acquisition of a request. Obviously, we have people who've left us land in their wills. I'm actually sitting on the Land Trust of Tennessee. We own a farm, 64 acres that was a bequest to us in 4 miles from downtown Nashville. It has an 1857 home on the property. I'm sitting in the house right now. That was a bequest to that organization in 2006. Some land trusts own a lot of land and have preserves and public spaces that they allow the public to come on and hike and recreate on their properties. We own a couple of pieces of land, but that's not our primary way of conserving land here. We have a few exceptions to that, like where I'm sitting right now. Some land trusts combine tools, so that would be doing a conservation easement, and then maybe also at some point selling that land to a public entity to become a park. So there are ways you combine the tools. Conservation easement and then a donation of the property to the county to become a park. We've seen that as well. And sometimes land trusts just play the facilitator or assist in a transaction. There's many times when, for example, I've helped landowners who, okay, I want to donate my land to the state park system. It's actually not a super easy process for a landowner to deal with that donation process or sale to the government. So sometimes we just play the facilitator role of helping them through that sometimes painful process of working with the government. So sometimes we call that a success if all we've done is help the land go from a private to maybe a public type use. So back to conservation easements. Since again, like I mentioned, that's our primary tool here for conserving land. And you'll see that a lot of land trusts around the country as well. And at the end of the day, it's a real property interest that's established through a voluntary agreement between a landowner and a holder of the easement. That can be a land trust, and also could be a governmental agency that can sometimes hold conservation easements. But the goal of this agreement is to permanently limit development of the land in order to protect conservation values. And each property is going to have its own unique conservation values, and a conservation easement clearly spells out right at the beginning of this long document what are those conservation values that we're trying to protect. So that could be a variety of things. As I mentioned, even here in Tennessee, we work on a lot of different types of land, but the conservation values can be scenic. You're providing a scenic benefit to the public when they drive down the road and get to enjoy that beautiful open piece of land. It can be agricultural to protect those working lands. Agriculture is still a huge part of our economy here in Tennessee. It can be historic, as I mentioned. natural habitat, conserving those places for our, our species and our rare species to live and thrive. Watershed protection, protecting rivers and streams, drinking water sources. That can be a really important conservation value, and potentially public recreation and education. So all of these conservation values we will spell out, but then we'll also make the case of why they serve a public benefit. Because at the end of the day, we are charities, we are set up, as nonprofits, and so we are always making that case. Even though we're protecting private land, we are serving some sort of public benefit through all of our transactions. Even if the landowner is not going to let people on the property, we're still providing some sort of public benefit through one of these different values. I'm going to refer here to the Treasury regulations, but again, I mentioned if a landowner wants to pursue the federal tax benefits for conservation easements, which I'll get into in a second, they have to meet the regulations on that. And so the Internal Revenue Code described this as a contribution of qualified real property interest to a qualified organization exclusively for conservation purpose. So we have to set that up right in our documents as well, that the landowner is doing this for conservation purposes. And it must be a perpetual restriction. And I know a lot of law students are like, no, we learned in law school, nothing can be forever. Well, we're the massive exception to that. Our state enabling law here in Tennessee and in all the other states, state enabling laws, it allows us to do permanent conservation easements. So the intent is that these are running with the land, no matter who the owner is in the future. So you'll have to just kind of get rid of that for a minute, but nothing's supposed to be permanent, well, these are. And that's the so conservation purposes that are outlined by the Internal Revenue Code talk about public recreation and education, protection of relatively natural habitat, protection of open space, and this is where you can get into the scenic benefit to the general public, or a clearly delineated governmental policy. So this could go back to some of the things Heather mentioned. Maybe in your comprehensive plan, maybe in a local park and open space plan, even sometimes in your zoning ordinance or maybe a conservation overlay, the government might have clearly laid out a policy of we want X types of property to be conserved, or we want X part of our county or our town to remain open and rural. So you can point to a very clearly delineated governmental policy in order to meet the regulations. We don't have as much of that here in Tennessee. We have also probably like half our counties don't even have zoning regulations. So we don't typically here depend much on our clearly delineated governmental policies, but some states use that a lot as a defense or why the property is important to conserve. And then you can, under here, talk about historically important land area or a historic structure. We do not do preservation easements or facade easements, you might hear them called. That's where you're actually restricting the facade of a structure to maintain its historical integrity. That would be a preservation or a facade easement, but that's also what they're talking about here when they talk about this historic structure. Again, that's more of the historic preservation type organizations that would use that tool. Easement, most important thing for you to remember is the landowner remains the owner of the property. So this is just a restriction on the use and development of the property. So the landowner maintains ownership, they maintain management responsibility, so they can still live on the land, they can decide to keep it private, they can post their no trespassing signs, or they can let people hike if they want. They can sell the property, it would just be sold subject to the conservation easement, or they can pass it on to their children or their heirs, or donate it to the church, or whatever they want to do, because they're still the owners of the property. It would just be subject to the conservation easement. So the conservation easement document, right in there, as I mentioned at the beginning, We document all those conservation values, and then we get into what types of uses and improvements are going to be limited on the property. So it will limit development. We spell out right there in the document how many residences are going to be permitted on the property, both existing and potential future residences. We're going to limit the ability to divide the property. So our goal, as you can imagine, would be to keep large pieces of land intact, but some of our landowners do retain the right to divide the property, maybe 1 or 2 times, depending on the size. We are going to limit certain uses. Most of our landowners can continue to farm. They can continue to cut timber, manage their forests. We ask them to do that subject to a forest management plan, and not just set someone loose on the property to cut trees. They can still hunt, fish, recreate, do any of those kinds of uses. But they are going to give up other uses. They're not going to, for example, be able to mine the property. They're going to give up the right to do any sort of mining in our conservation easements. Of course, they're giving up a lot of their development rights, but for the most part, they're retaining all those other rights that they aren't giving up under the easement. And part of the conservation easement is that it is giving us, the land trust, the right to enforce and monitor the property. So we're going to talk more about that, but it's giving the land trust certain rights to approve activities on the property. Each conservation easement is customized, tailored to the property, the conservation values. We have landowners who have done parts of their property and then phase it in over time, or might never do another portion of their property. It's a voluntary tool. We are not forcing anyone into this type of agreement. And it can be done post-mortem. So a landowner and their estate representatives can elect to do a conservation easement as part of their settling their estate. So that is an option for people who didn't make that decision during their life. The benefits, obviously, peace of mind. A lot of people we work with just are so glad that they know when they're gone, their land will still be there. And they love being able to tell developers to go away because they've restricted their property. So peace of mind. I think landowners, like the idea of forever. And so even if the land changes hands, even if their kids decide they don't want to live there, they want to sell it, it'll be conserved. Our job as the land trust is to monitor and each property annually and also enforce the terms of the easement in perpetuity. So talk a little bit more about that in a minute. Quickly touching on the tax deduction. I don't want to bore you guys. I know you didn't sign up for tax law class here, but it is an important part of what we do. To explain it, so landowner, let's just say they want to protect their 200-acre farm. The current value of that farmland, this clearly is an old example because our land values are insane right now in Tennessee, but an $800,000, let's just say an appraiser comes in and says, okay, the current value of your land is $800,000. Then they're going to value it again after the easement. So the land with restrictions on it, let's say that's worth $500,000. And it's the difference between those two numbers, so before and after. So in this case, in my example, $300,000. That is recognized as a charitable contribution. So a landowner can deduct $300,000 in value from their income tax. Now, it's a tax deduction, and so you would apply that to your adjusted gross income, and you can deduct it up to 16 years. So it can be a huge benefit for people. They can deduct it the year they do the easement, and then 15 additional years if they have an additional carry forward deduction. So the next one, so this shows also there's a different tax benefit if you're just a regular landowner or if you're a full-time farmer. A full-time farmer can deduct even more per year than an average landowner. So they're treated slightly differently in the regulations. Again, trying to incentivize some of our farmers to conserve their working farmlands. I mentioned earlier purchase easement. So here in Tennessee, we don't have a lot of funding available to help landowners conserve their land. So almost all of our landowners are doing this as a donated easement. And the benefit they can receive, in addition to all the softer benefits, they would be potentially eligible for the income tax deduction. In some states, in some cities, and some counties, there's programs where they can actually pay landowners to do conservation easements. So this is what we call a purchase easement. So instead of taking that as a tax deduction, you might get paid the cash value of those rights you've given up on your land. So same example, an appraiser would come in, value the land before the easement, after the easement. The difference between the two is valuing the value of that conservation easement, and that a landowner might receive that in cash instead of the tax benefits I mentioned. We do, an example here in Tennessee, we partner with the Army up at Fort Campbell Army Base, and we do buy easements. So the Department of Defense is giving us funding to purchase conservation easements from landowners buffering the base. Because their goal is to keep people from living right up along their high noise zones where the helicopter is and the Black Hawk helicopters fly in and out. So to them, it's a training priority, and we're able to offer landowners cash to conserve their land up there around Fort Campbell. That's one example we have. But in some states, that's all they do is purchase conservation easements. Sale. So a landowner, let's say, again, in my example, you have a conservation easement worth $300,000. You might get $200,000 in cash and then take the remaining $100,000 as a deduction. So a bargain sale is when you're combining an acquisition with a donation type tool. So you can do the same thing for a conservation easement. I'm going to go through 3 quick examples of some different types of projects that we've worked on. This is here first is a working farm. She is a landowner. This is a multi-generational. She's owned it. Her parents own it. Her grandparents farmed it. So it's really important to her to protect for open space. Rutherford County is not far outside of Nashville. It's a rapidly growing area. So this is a pretty typical project for us to work on. We have scenic conservation value, agricultural open value, and then just open space. We're conserving open space in an area that's starting to see increasing development pressure from Nashville. And so right in the conservation easement document I mentioned, we set out upfront what is going to happen with development on this property. So we set up, and this area here in blue is where her existing home is. So we set up a rectangle called the homestead area. And in that area, she can repair, replace, maintain, enlarge, do whatever she wants with her home. She can build accessory buildings, garages, gazebos, sheds, swimming pools, all of that would be in that homestead area. And then down here in the lower corner, she set up an area where she can build a future home. So notice that that's just a point on the map, but at some point in the future, whether it's this landowner or a future landowner, they can establish that area and build another house there. So we've spelled all that out right in the document. So residential uses are allowed in a limited way. Agricultural uses and structures, in this case, she can come to us and say, hey, I really need a barn. In the land trust, we have the right to approve that if we feel like it's consistent with the terms of the easement. We mentioned forest management. She could continue to do forest management in this section of the property. And then she retained the right to divide the property. So right here along the road is her division line. So at some point in the future, not now, but at some point in the future, she could end up with 2 distinct farms that are all both subject to the same conservation easement, but they could be separately conveyed. So that's an example of where she's retained the right to divide the property. This makes a lot of sense when you have this physical boundary like a road going right through the middle of the property. So that's a typical working landscape that we might do a conservation easement on. Going to go through for us, but this is a group of developers we worked with who wanted to conserve some open space adjacent to one of their developments. This is in Williamson County, which is the county just south of Nashville. You can see what's happening in this area, highly residential area, just again, maybe 15 minutes from Nashville. So here, clearly protecting open space and that kind of, relief from development. We did have a clearly delineated governmental policy. So the city of Brentwood has an open space ordinance, and so we were able to say that this is consistent with that open space plan in our conservation easement. And we were also providing habitat. This is one of the few areas left that is not, as you can see, developed. So it is providing important habitat for some of our forest. It's a forested area. So this one, the original plat that the county had approved them up to 27 homes. The conservation easement limits them to 2. We had 4 potential sites, and they can choose 2 in the future to build on. So the conservation here, obviously taking it from 27 lots to 2 is a conservation win. But also, they could do forest management, so it's a forest management plan. They're obviously retaining the right to do trails and recreation on this property, because you can imagine they might open this up to the homeowners in the area to come and hike and walk in the woods. And they retain 1 division of the property. I mentioned in Tennessee, we don't have some counties that don't even have zoning. This is an area, the city of Brentwood has strict zoning ordinances. So we did work closely with the city too, when they were choosing these sites, to make sure it was consistent with local zoning ordinance, and they have a hillside protection ordinance. So the homes had to be located in a place that wouldn't violate, obviously, any of their local ordinances. Developers have to be careful when they enter into conservation easements. We definitely have gotten calls from developers to say, oh, I have this great piece of land that I want to conserve. Well, a lot of times it's a little bit of a too good to be true. It's either land that they can't develop in the first place. Maybe it's undevelopable, steep slopes, bad soils, whatever reason. Or it's an area that they already promised to keep open as part of getting their subdivision approved. So if they've already said, on their plat, as they go through that approval process, oh, this area will remain open space, they can't then do a conservation easement and expect to take a tax benefit, because they've already basically given up that area as open space. So the developer really has to be going above and beyond what would be required by their local approval process if they want to pursue any sort of tax benefit for the conservation. And it has to be land that has development value if they're going to be giving up some of that value and try to take a tax deduction for it. So developers have a fair amount of pitfalls when they consider this. Also have to look at enhancement. So is this beautiful open space they're conserving, is it enhancing their adjacent development? So these landowners now will be looking at lovely open space, they can hike on it, they can recreate. Is that actually making their development more valuable by being adjacent to the open space? So developers have to consider that as well when they're considering conservation easements. Here's a project we're working on right now that kind of combines a lot of different things. This is a working horse farm in the Memphis area. It's intended to become a public park. So this property has significant open space value. You'll see in a minute, highly developed area of Memphis. It will have public recreation at some point. It's a historic horse farm. It's on the National Register of Historic Places. And so in this conservation easement, it already has residential use, it already has agricultural use, and we're setting up, as you'll see in a minute, some no-build zones to kind of make sure to retain that scenic character. And then there'll be anticipated recreational uses and trails. Well, because right now it's privately owned, but she intends for it to become public at some point. So kind of having taking both of those uses into account. So in this private property, we set up a no-build zone all along the boundary of the property. And then she has a significant area here in the middle with all of her structures, her house. Several of their outbuildings and the farm structures are here. And then all of this is set to stay completely open other than trails and maybe some type of park uses in the future. So this one's interesting. We're having to take the current land use into account, but also start to plan for the fact that we know this property might be public, and we have to allow public type improvements like trails, restroom facilities, parking areas, things like that. So it's an interesting conservation easement that has to address both current and future use. For us, stewardship is everything after you close the easement and sign the easement and recorded the easement. So we have people on our team whose job just is to do the stewardship part. So that's where our job comes in, is to make sure these conservation easements are upheld in perpetuity. So we monitor the property annually to make sure nothing's going on the property that shouldn't, would be a violation of the easement. It's also just really important to meet with the landowner and hear about any future plans they might have. That way maybe we can prevent a violation in the future. If the easement is violated, we do have to try to work with the landowner to remedy those violations. And that's a whole other topic for another day. A big part of our job is approvals. So as I mentioned, landowners may retain the right to build a house or build a barn. But at some point that will require land trust review and approval. So we spend a lot of our time doing those kinds of activities. Interpreting the easement, sometimes the landowner just calls us and says, hey, can I do X or Y, or I'm not sure what this means. And so we work with them to try to interpret what those words mean to us and to them. As you can imagine, we have some of our older easements that maybe aren't our favorites. So we've been doing some interesting work trying to interpret what was intended when our staff wrote those easements 20 years ago. So record keeping is really important. Condemnation. Yes, the government can still come in and condemn conservation easement property. So we do work with the landowner and the condemning agency to try to minimize the impact, but also make sure that proceeds go, go to the landowner and the land trust both when property is condemned. So that could be for a road widening project, a utility, those kinds of things. We're seeing, unfortunately, a lot of recently. Property transfers, so we want to be involved when the land changes hands, whether that's to the heir of the original person or they've sold the property. We want to make sure that next landowner understands the conservation easement, knows who we are, knows they can pick up the phone and call us. But it's a partnership. So we want to make sure, so we spend a lot of time trying to get to know those new owners. Or fielding questions from potential buyers of a conserved property. And I mentioned landowner relationships, so that's critical to what we do. We want to be partners, not the police, even though, yes, sometimes we will have to enforce the easement and maybe end up in court, but we try first to maintain good working relationships with our landowners to try to avoid problems down the road. And then these topics came up already, but some hot topics for us in land conservation right now is, climate change. Are these land uses, these conservation values we're protecting today, are they going to change? Are they going to shift? We might be trying to protect X rare or endangered species or a certain type of land. What's going to happen as our climate starts to continue to change and habitats change? So we're all thinking about how do we have to adapt our drafting and change our conservation easements to start thinking about that. Especially hot topic for coastal land trusts, you can imagine. Lands they're conserving today, what do they do? Sea level rise? Are these properties going to be, still there? It's conservation. So it's a definitely important conversation we're having. Community conservation, diversity, equity, and inclusion. How are we getting underserved communities to have access to open space and our parks and public spaces? And also, I think conservation has been somewhat private. We're working with private landowners. We're kind of doing this thing over here. So how do we make it more acceptable to more people and make it just part of our important infrastructure, honestly. Parks and open space should be considered just as important as our roads and highways and all of that. So how to be more inclusive in conservation is a very important topic now. And then IRS challenges in the tax court. We don't have time to go in this today, but there have been some fraudulent transactions going on that have led to a lot of IRS challenges and a lot of unfortunate tax court cases that are affecting the entire community. And it's all because people are doing, I would say, some fraudulent transactions out there. But that's a really big part of what we're talking about today in conservation. All right, I think that was my last one. I can't get it to quit, Caitlin. Oh, there we go. All right. Yes, well, I think you can find me through the website too, but there's my information. And then I appreciate being part of this great panel today. So.
Great. Well, thank you so much. And I think we do have quite a few questions, and a reminder to our participants, you can enter those questions using GoTo's question box. So I'm just going to pitch these to our lovely panel today. Any of you are welcome to answer any of the questions, some of them, whichever ones you want or not to. So our first question, one of our participants writes in asking, how can municipalities claim that zoning is good for public safety? For the example this participant gives is construction of roadways that don't fall on a grid system, or cul-de-sacs that could be poor choices for police or fire responses, and just anything any of you may want to add on there.
I don't know, Sarah, if you, can you guys hear me okay? Good. And my electrician is here, so apologize if there's background noise. I don't know, Sarah, on the legal side, if you wanted to answer that, but I guess, for any projects and when roads are built, they are evaluating for adequacy and for safety. So I think even in instances when maybe streets aren't in a grid system or cul-de-sacs are built, both of which concepts I think probably seem somewhat antiquated to some of the folks on this call, because it's not really in furtherance of sort of urban design principles. At the same time, they are evaluating those streets for adequacy and safety, even if maybe we all agree that it's not the best sort of urban design. So they are still doing those technical analyses. I'm not sure if anybody has anything to add on to that.
Thank you. Another participant asks, and this might be a question for Emily specifically, can land trusts or other conservation efforts ever play a role in land back type efforts to restore sovereignty for disposed indigenous lands? And how do current US law land interact with these kind of issues in general?
Yeah, I think that, yes. I think it depends, again, on your land trust and your mission, but I think definitely a conversation that's going on right now. And interestingly, a term that's relatively new, but called cultural easements, but it is more about allowing access or, inviting back some of those communities that were displaced from the property. And there's a pretty interesting land trust I know locally here in the Southeast that is working very closely with the Cherokee Nation in the mountains of North Carolina to help them conserve some of the areas that would have been very sacred to the Cherokee people. And so, yeah, it is interesting because it almost is, at least here in the Southeast, we're not working much with the government. They're not working much with the government. It is between the landowner and maybe that, the indigenous population, as opposed to maybe in the West, it might involve more of our federal land regulations. But I don't have a lot of experience with that here in the Southeast, just because again, we don't have quite as much of that as they do out in the West, but definitely an area people are talking about. We're also hearing this with heirs property and try to help African-American families who maybe also the land has been, the way it's been deeded over the years, there might be 50 heirs that all own a piece of land and they don't have good documentation or deeds. And so helping those families secure their ownership and make sure it's done correctly. It's really important as a first step to then maybe conserving that land. So heirs property is a really interesting thing happening around the country as well.
Thank you. Our next question, I believe, is for Sarah. How difficult is it to prove unequal treatment?
Well, it's unequal treatment. I assume that's a question in the context of a violation of the Equal Protection Clause. And like I was attempting to explain, in zoning, it's really going to be unequal treatment within the same class or category. So you'd have to prove that, homeowner A or property owner A is going into the zoning office asking for, use, and they're being treated differently than homeowner B was when they came in and asked for the same use approval 6 months prior. You're going to have to find some real clear evidence of disparate treatment between similarly situated people.
Perfect. Thank you so much. Let's see here. Another participant asks, the assumption with paying the landowners for a conservation easement is that land is always less valuable with a conservation easement on it. Do you, and this is for Emily, anticipate the valuation of land may start including long-term conservation certainty?
Yeah, that's interesting. Yes, I think there's a lot of, kind of those intangible benefits to conservation that we know of in the conservation world, but trying to get an appraiser to value what those are is another challenge altogether. I think, appraisers are just going to look at the things that are more straightforward to value. So yes, I think there is a very important value and potentially even an economic value in conserving these urban spaces, but translating that into a defendable appraisal would be a big challenge. I also will say, yes, these landowners are giving up value right away, but I would argue over time that land is going to become just as valuable again, potentially, or maybe even more valuable because it's going to be some of the rare open space potentially in a community. I think they're already starting to see that in some places in New England for sure, where they've been doing conservation longer, but those land values have gone actually back up. Even though, yes, there was an immediate loss in value on the front end.
Thank you. We have another question for Sarah. How does the APA apply to zoning issues? Do most states have their own laws similar to the APA?
The APA, I think that would be considered, with planning professionals, that's their organization where they can receive training. I think it's a great resource for articles about planning and definitely, the interaction of planning and zoning. It can be a really good resource for suggested treatment of certain uses. So Heather was referring to some, obviously climate change is presenting us with some unique challenges that were not envisioned when that standard planning document came around in the 20s. On that cycle with planning, jurisdictions have to start figuring out, where do we want our electric charging stations for electric cars? Where do we want, what are we going to do in these vulnerable areas where, we could have saltwater intrusion, devastating effects of flooding from climate change related pressures. So for those specific things, I think it's a really good resource to sort of see nationally how planners are addressing it. And it can be a good place for folks, like your State Department of Planning, they can contribute resources there. So I would think of it as sort of more of a resource hub.
Thank you. One of our participants asks if we can talk a bit more about how land use, especially, zoning, et cetera, can be utilized in terms of addressing disparities, especially racial or low income disparities in land use.
Can you repeat the first part of that question one more time, Caitlin? I'm sorry.
No, it's okay. And I'm trying to kind of piece a little bit of this question together, but a participant just wants to know how land use and zoning can be used to address current and historical disparities, especially in terms of low income or racially diverse areas.
Right. Okay. It's a really important question. And again, I think it's an ever evolving concept. I don't think we're close to being in a perfect place with how this is done. But I think flexibility in terms of types of housing is really an important place to start with that. Like I said, we do sort of have this unfortunate history of preserving certain zones for single family dwellings. And this real estate market showing us right now that that's not an attainable goal for everyone. It might not be appropriate for everyone. And so some of the tools that Heather was talking about, such as overlay zoning, where you would be able to, a jurisdiction could craft an overlay zone, giving flexibility that a developer could then come in and apply for with that local jurisdiction. And, then it provides flexibility for both parties. It would provide flexibility for the developer to be able to develop property with a mix of housing styles. So, apartment type dwellings, townhouses, condos, and houses, instead of just having, a large scale development with, a big house on 3 to 5 acres. And it also gives flexibility to the county. So if they create some of those goals in their long-term planning document, important, like Heather was saying, to think about equity when you're thinking about what you want the future of your jurisdiction to look like. If you have areas of your jurisdiction where you think, we've got some issues here, we're continuing to see low income folks in this one area of town and it's not changing, that's going to be something that can be addressed with this duality of planning and zoning. So we're going to have to set planning goals that we want to have more inclusive housing, that we want to have more flexibility, that we want our neighborhoods to reflect the diversity of the community. And then you're going to have tools in your zoning toolbox, like an overlay zone, where something like that could be reviewed, approved, and sort of put into place. So I think there's a lot of tools in the toolbox for addressing diversity and inclusion issues. I'm optimistic about it, but it definitely takes creative, dedicated, and professional folks with the experience to make sure that planning and zoning duality are put into place.
Thank you. Definitely an important topic, and I appreciate you expanding on that. We have a question, I believe, for Heather. One of our participants asks, have you seen any counties using overlay zones?
Yeah, I think it depends on the jurisdiction, but for example, just using Montgomery County as an example, there are a lot of overlay zones here, and they are for sort of different reasons. There are environmental overlay zones, so areas that are like special protection areas that are sensitive watersheds where maybe they want to limit the maximum impervious surface on a property to something lower than like the base zone allows to protect the watershed. So you have things like that. You have things like overlay zones in more urban areas. I think one of the ones I put up on the screen, the Ripley South Silver Spring overlay zone, that has a pretty unique character, sort of smaller scale businesses, mom and pop, if you want to call it that, sort of traditionally smaller scale and a little different from the rest of Silver Spring. So like that overlay zone was to sort of help protect the different type of character and the unique and positive character of that area. So I think it really depends on the jurisdiction, but I do think to some degree, you're seeing overlay zones increasing. And I think maybe to Sarah's point from a minute or so ago, sort of the utilization of overlay zones to accomplish more specific goals and purposes that are not necessarily broadly applicable to one entire zoning category, but maybe applicable to a specific area. So I would say depends, but I think in some jurisdictions you're seeing it more.
Thank you. Next, we have a question for Emily. How are organizational and operational costs of the land trust financed?
So we're a nonprofit, so we are almost completely funded by donations from individuals and foundations. We have a little bit of corporate support, mostly they sponsor events and things like that we have. We have some small government grants as well. I mentioned our partnership with Fort Campbell. So they do, when we're working on projects for the Army, they do cover our staff time and some of our expenses. We have a small grant with the state. Actually, we don't right now, but we historically had a grant with the State Department of Agriculture that we can use to cover some of our costs when we're working with farmers who want to conserve their land. But yeah, we're mostly almost completely supported by private individuals, small to large donations.
Thank you. Our next question is regarding bicycle lanes. A participant asks if we could clarify what a frontage improvement is for bicycle roads.
I'll take a stab at this because I was discussing them. It depends. So, for example, the bicycle master plan that I was mentioning has many different types of possible bicycle lane sort of concepts, and then frontage improvements required to implement that. So there are places where, for example, the plan may call for a 2-lane bikeway all on one side of the street. So you're accommodating, for example, like a 10-foot bicycle lane, either within the right-of-way, the existing right-of-way, if there is space for it, or if there is not space, it may be assumed that it will go on your property frontage and you have to accommodate that. It also could be a one-way bicycle lane, and sometimes they have the other lane on the other side of the street. Sort of shared use paths, which may then actually be a bicycle lane in addition to a walking lane, which could be maybe as wide as like even 15 feet. So you have to look at the specific bicycle master plan to see, first of all, if it calls for bicycle improvements on your frontage, and then what specifically, sort of section, what type of improvement it calls for. Hopefully that answers the question.
That does. Thank you so much. We have another question. A participant asks how homeowners associations regulate the use of one's land.
Oh boy, homeowners associations. It's a layer. It's definitely a layer of restrictions. It's a good point. Probably should have mentioned it earlier, because definitely not something to be ignored, and a lot of people, because they don't like them, they like to ignore them, and then they rear their ugly heads. They're not all bad, they're just can be a little unwieldy, and I think sometimes folks underestimate them, especially when they're buying property. I fear in this hot real estate market that people are going to be doing that and then end up unhappy with some of the restrictions. I mean, the answer is, you've got to look at what your zoning is and what those restrictions are. And then if you have a piece of property that's subject to homeowners association covenants, that's going to be another restriction. So if your underlying zone says you can have backyard chickens, but your HOA says nothing other than pets, no farm animals, only cats and dogs in the neighborhood, that's going to be what you're going to be subject to. So land use restrictions, it can be an onion, and you got to make sure you look at all the different layers. And homeowners restrictions, sometimes they can be very antiquated and they haven't been updated over time, which can be a problem. A common restriction is no home-based businesses, home occupations. And that's a real tricky one, especially where we are now with everybody working from home and not necessarily thinking about what you're doing out of your home as a home occupation. You know, you don't have a bunch of customers coming in and out, but you know, if you're running a business out of your home, it's definitely something to think about, especially if you're contemplating a piece of property where you want to be doing that.
If I could just add something really quick, so I thought this might be helpful for the participants. What Sarah said about this peeling the onions notion. So aside from homeowners documents, there could be any number of like different types of private covenants on a property. So reviewing title and survey, especially if your client is getting ready to purchase a property, is super important. So like one example is I had clients who were seeking to purchase a property, and you know, it's zoning allowed what it did, but years ago the prior owners sold off the density from the site. So and transferred to a nearby property, which is sometimes permitted under zoning. So I don't want to belabor the point, but to Sarah's point of many layers of the onion, you need to be checking title on a property, because there could be any number of things recorded against the property and encumbering it that may be much more strict potentially than the zoning itself.
Thank you. This has been great. I think we have time for one more question, and appreciate the panelists taking so many and the great ones that are coming in. A participant asks, what is the process to challenge a zoning ordinance or rezoning?
I don't know. I don't do opposition work, mainly just because it's easier to play in one field, or not field, one side or the other. So I'm not best to speak to this. I don't know, Sarah, if you may have more thoughts than me.
I mean, if you're challenging a zoning ordinance, you're going to have a basis, you know, on which to challenge that ordinance. And that's why I pointed out some of those foundational underpinnings that I did at the beginning, because those things make up a lot of the successful challenges. It is hard to challenge a zoning ordinance because of the deference that's given to local jurisdictions. Most local jurisdictions are going to pass a law, you know, tied to police powers. They're going to be able to cite a rational basis for the law. Rezoning, you know, like Heather said, you know, there's the change or mistake rule is very, very difficult to actually, you know, put into practice. You literally have to find a mess up, a boo-boo. I mean, a mistake when they were doing it. They, you know, they were looking at an old map. They got the property lines wrong. They zoned this rural residential because the next door, they thought the next neighboring property was rural residential, but 6 months previously that had actually been changed somehow. So that's going to be difficult to prove. And I agree with Heather. I mean, I did that in private practice. You end up having to babysit things for clients and advocating during the planning process and then during the rezoning process. That's the best way to really to make change. If you're, you know, if you have a client who's very unhappy with their zoning, it's going to be, you know, it's going to be a process. They're going to have to be actively involved. And that's a lot of times why they hire attorneys to be actively involved. And if you end up practicing in this area, these rezonings and the rewriting of the comprehensive plan, that's going to be a part of your life. That's going to be a part of your career. You're going to know those documents inside and out because you sat in meetings where people, you know, parsed words and thought about every little thing. Which is great because if you sit there and you put in the time, sometimes you can really help your client and get them what they want and effectuate what the jurisdiction wants. You know, oftentimes things, you know, can be kind of hand in hand, but it's really, it can be kind of heartbreaking when you have a client come in and they say, love the property, just sign the contract, but I just need you to get it rezoned for me. And you have to give them a lot of the information that we've been giving you today, that's not how it works. And the reason that isn't how it works is because, as you can imagine, the inequities that would create. If folks could come in and easily get things rezoned without any reference to planning, planning would have no value, zoning would have no value, those nuisances wouldn't allow, you know, we wouldn't be discouraging those nuisances and the whole thing would kind of be useless. But the client who comes in and asks for that doesn't want to hear that answer, but that's the answer.
Thank you so much. And I feel bad that I have to wrap this up because this has been such a great conversation. We really appreciate our participants joining us today. So many great questions. We hope you'll continue to think about many of the topics raised today. We're so grateful for your participation in ELI's annual summer school seminar series. We hope to welcome everyone back next Tuesday for the basics of the Clean Air Act. And of course, I want to extend a huge thank you to our fantastic panel, Heather, Sarah, and Emily. You all have been fantastic. Thank you so much for lending your expertise and your leadership to summer school. I hope you all take care, and thanks for joining us.
Take care.